So let's get started. This is the fourth roundup of current affairs we have discussed from August to January 2016. In this lecture, we'll talk about February and March. And let's not forget that in February, we have had railway budget, general budget, economic survey. But these are the things that we will not discuss in this lecture. Why? Because separate lecture on economic survey and budget is there on your schedule. So we'll have that separately. So in this lecture, we'll talk about all that is important from the prelims point of view from the months of February and March, covering all the important sources as we do every now and then. So let's get started, beginning with issue number 1. Supreme Court guidelines now protect Good Samaritans who help road accident victims. This is the news that was dominating the headlines. Let's talk about all that you need to know regarding these guidelines. But who are these Samaritans? Samaritan means a charitable person or a helpful person. Now, what was happening? I happened to witness an accident, but I do not come forward to help the injured. Why? Because police will force me to become a witness in this case. Not just this, I'll have to be present in the hospital and fill all the forms required. Even after I leave, I'll be called by the police to the police station. Why? To record my statement. I'll have to be present in the court when the matter will be taken up. Police may come to my house to question me, and my neighbors will think that I've committed a big fraud, murder, or rape. This was preventing people to help the injured in the road accidents. Law Commission of India observes that 50% of those killed in roadside accidents could have been saved had timely assistance been rendered to them. Had someone from the bystanders help this individual, take them to the hospital and take care of all that is there. That means 50% of those who are killed in these accidents might have been saved. Then what happened? Save Life Foundation filed a public interest litigation in the Supreme Court. Save Life Foundation conducted a study. This study found out that 3 out of 4 people in India hesitated to come forward and help the road accident victims. 3 out of 4 people. And 88% of these individuals think that they do not want to help the injured. Why? Because they fear the police. They fear unnecessary detention at hospitals and prolonged legal formalities. This is the background. This is why people were not helping the injured, and ultimately the very, very crucial human resource we were losing in these road accidents. Public interest litigation was filed. Supreme Court asked the government, please frame the regulations that will help these good Samaritans, those individuals who will help people in road accidents. Government regulated, approved the guidelines, created the guidelines, and gave these guidelines to the Supreme Court of India. And 30th of March 2016, the Supreme Court approved these guidelines to protect Good Samaritans. Now let's talk about what are these guidelines. These can be potential questions in the prelims examination. Guideline number 1, very important statement from the prelims point of view. Any individual except an eyewitness who calls the police to inform them of an accident or he or she need not reveal his personal information. I happened to witness a road accident. I saw injured lying on the street or unfortunately death taking place. What I will do, I'll pick up a call and inform the police. The police will not ask me any further question. They will not ask me to reveal my identity. I may or may not reveal my identity, but police will not force me. I do not need to reveal my personal information. Not just this. If I take individual to a hospital, I provide some information to the police, where exactly happened the accident took place. I'll provide this information and I will leave. I won't be forced to stay or reveal any further information, like Who hit whom? Who were the other people witnessing the road accident? Who do you think is the culprit in this case? This information I need not reveal to the police because this is unnecessary harassment of a good individual who has saved a roadside accident victim. But can I become a witness? I can become a witness, but I will not be forced to become a witness. These were some of the guidelines which will protect these good Samaritans. That means I saw an accident. I witnessed an accident. I revealed the information to the police, but I will not be forced to reveal any further information or reveal my identity. But what if I volunteer to become a witness? There are some protections which are available to witnesses as well. What are these protections? Protection number 1. I am a witness, right? That means I have to record my statement, right? But where? At the place and timing of my choice. Can police come to my place to record my statement? Yes, but they will come only in plain clothes. These are some of the guidelines which protect the dignity of these good Samaritans who help the roadside victims. That means even if I want to become a witness, I can become a witness, but even then I will have some safeguards. Like I will have to record my statement at the place and time of my choice, even if police can come to my home. Why? To record my statement, but they will come only in plain clothes. Now let us look at some of the questions that can be framed by the UPSC on this particular matter. I'll give you 2 statements and you will have to tell me which of the following statements are correct. All the good Samaritans will be awarded by the respective state governments on Republic Days. Statement number 2, a good Samaritan will be suitably rewarded or compensated to encourage other citizens to come forward to help. This is a 2-statement question that can be asked by the UPSC. Statement number 1, all the good Samaritans will be awarded by the respective state governments on Republic Days. This statement is wrong because it is not mentioned in the guidelines. But what is mentioned is statement number 2. That means a good Samaritan will be suitably rewarded or compensated to encourage other citizens to come forward to help. So this brings us to the closure of issue number 1. Let's look at the another issue, which is very, very dominating in the headlines and television studios. The bill talks about Aadhaar, or the full form is Targeted Delivery of Financial and Other Subsidies, Benefits and Services. Now, what was happening in the past? The government is providing subsidies to the people, but there is something called leakage. That means if 100 rupees subsidy is given by the government to an individual, 50 rupees in the midway are taken by the middlemen. That means ultimately, what is the amount of money that is received by this beneficiary? It's very little. If we go back to 1980s, Rajiv Gandhi said when he was the Prime Minister, 1 rupee money which is given to the states, to the individuals, to the beneficiaries, to the disadvantaged sections of our population, out of that only 1 paisa is received by these individuals. That means there is something called leakage, and which is a huge burden on the state exchequer. How to plug this leakage is simple. Simple in the sense, allocate a unique identity number to any beneficiary, link it with the bank account, and you will directly transfer these subsidies to the bank accounts of these beneficiaries so that middlemen will not take away anything out of this subsidy, which is meant for the poor and underprivileged sections of our society. Now, to do that, the government has enacted an Aadhaar Act, which talks about giving subsidies on other services to individuals, other services such as scholarships. And these subsidies and services will be rendered to individuals residing in India. How? By assigning a 12-digit Aadhaar card, which will be a unique identity card available to every single individual in this country. But from prelims point of view, let's look at something else. Aadhaar card. Who is eligible to get this Aadhaar card? So first thing we should be clear about. What is this Aadhaar Act trying to do? It is trying to provide subsidies and other services to the people by directly transferring subsidies to their bank accounts, and also a unique identity card will be given. Why? Because to ensure that there is no duplication. Because what was happening, if I am a beneficiary, I used to get subsidies twice as well, because I was faking my identity. But if every individual is provided a unique identity number, there will be no duplication possible, and ultimately the state exchequer will not be overburdened, money will be saved. That means targeted delivery is an important point. But who is eligible to get this Aadhaar card? Only the citizens of India. The Aadhaar Act states all residents will be eligible to get the Aadhaar card. That means even foreigners will be eligible to get this Aadhaar card. That means the Act states any resident who has resided in India for the past 182 days before or prior to his submission of application to get an Aadhaar card. I submitted an application today to get the Aadhaar card. If I was staying in India, residing in India prior to 182 days, that means 482 days before making this application, I am eligible to get this Aadhaar card. That means not just civilians, not just citizens, but also the foreigners are eligible to get this Aadhaar card. Another very important statement. Aadhaar is merely an identity card or identity proof of an individual, a unique identity, but it's not a proof of citizenship. A foreigner who have had an Aadhaar card will not claim tomorrow to become citizen of India based on the fact that he possesses an Aadhaar card. It's not a proof of citizenship. Let's look at something else. Enrollment. At the time of enrollment, that means if I want to enroll for an Aadhaar card, at the time of my enrollment, I will be given some information. Some information like the manner in which my information will be used. What sort of information am I providing? I am providing my photograph. I am providing my biometric details. These biometric details like an iris scan, fingerprint, because ultimately these biometric details will provide a unique identity to an individual, because these fingerprints and iris scans, they are unique. That means at the time of enrollment, when I will enroll for an Aadhaar card, I will be informed about the manner in which this information will be used. Not just this, who can be the recipients of this information, with whom this information can be shared, and also who will have the right to access this information. This we will explain a bit later, but primarily when I'm enrolling for an Aadhaar card, I will be told about all these things. And when I'm agreeing to all these things, I will be provided an Aadhaar card. But another important thing, this Aadhaar Act talks about Unique Identification Authority of India. This Unique Identification Authority of India will now become a statutory body. Because previously this Unique Identification Authority of India, which began during the UPA time, this was headed by former Infosys co-founder, Nandan Nilekani. But this UIDAI was set up by an executive resolution, government resolution. Neither was it a constitutional body, nor was it a statutory body. But this Aadhaar Act gives a statutory, a legal binding to Unique Identification Authority of India. That means it now becomes a statutory body. What will be the composition of this UIDAI? Another potential question from the prelims point of view. Let's look at the composition. Unique Identity Authority, this will comprise of 2 part-time members and a chief executive officer. But what is going to be the qualification of these chairperson and members? The Aadhaar Act states that these members must have experience of at least 10 years, but at least 10-year experience where? In technology, governance. That means Aadhaar Act primarily talks about targeted delivery of subsidies and other services. Who is eligible to get an Aadhaar card? Every resident. That means including foreigners. But is Aadhaar card a proof of identity as well as proof of citizenship? No, it's only a proof of identity. When I'm enrolling for an Aadhaar card, what information will be provided to me? And what is this Unique Identification Authority of India? This is what we have discussed up till now. But the fundamental question that you should be asking is, can your information be shared with others? Yes. But what sort of information? For example, you have given your information to the Aadhaar authority. Now you want to purchase shares. You want to buy shares or sell shares. That means tomorrow the stock exchange or the regulatory authority of stock exchange, SEBI, can ask your details from Unique Identification Authority of India. But only what sort of details? The details can be either my photograph or my demographic knowledge. That means where am I living? What is my proof of residence? Only these information will be provided because the Aadhaar Act explicitly states that it is not permitted to share an individual's fingerprint, iris scan, and other biometric details. The Aadhaar Act is absolutely clear on this thing. That means if any third party asks for the information, it can only ask your photograph, it can only ask about your demographic details, demographic knowledge. It cannot ask your biometric details such as fingerprints and iris scan. But can even these individuals' fingerprints and iris scan be revealed in some way or the other? Can even these biometric details be shared with any authority or body? Yes, but under two circumstances. What are these circumstances? Number one, on the order of a court. If the court issues an order to UIDAI that you please reveal the biometric information as well, the government will have no other alternative but to share even these biometric details. Number second, in the interest of national security. This is a phrase which has been heavily criticized by the activists. They say anything can then be determined as in the interests of national security. That means there is no privacy in this act itself. Under any circumstances, your biometric details can be released by the government because government will say that it is in the interest of national security to release your biometric details. But even then, such a decision, very important statement now, please keep in mind, such a decision to reveal this information, which is the biometric information, in the interest of national security, will be taken by an oversight committee. This oversight committee shall comprise of Cabinet Secretary, Secretary of Legal Affairs, and Electronics and Information Technology. That means basically what is happening, the Act states that your biometric details cannot be shared with any information, cannot be shared with any agency whatsoever. But under two circumstances, even your biometric details can be shared. These two circumstances are on the order of a court and in the interest of national security. But who will take this decision? That in the interest of national security, your biometric details can be released. This decision primarily will be taken by a joint secretary of the central government. But the decision of joint secretary of central government will be reviewed by this oversight committee comprising of these members, and this review will be valid for 6 months. That means your biometric details, when the order has been issued that your biometric details will be shared with an agency or a court, this decision to share your biometric detail will be valid for only 6 months. Even after 6 months, if your biometric details are still to be given to a third party, that decision again will then be taken by joint secretary and reviewed by this oversight committee. Another issue. Now all this information, these demographic details, biometric details are present in database. Fine. But what if some individual some employee, some official of the government will access this database and reveal this information, what will happen to this individual? This can be another question in your prelims, because if somebody accesses this database without authorization and releases the information, leaks the information, minimum fine would be 10 lakh rupees and maximum punishment can be 3 years. Minimum fine for that individual 10 lakh rupees, maximum punishment for 3 years. This is all that you need to know about the Aadhaar Act, which was recently passed. But there are some issues surrounding Aadhaar as well. That will Aadhaar not violate your fundamental right to privacy under Article 21 of the Indian Constitution? But these are the matters which will be primarily dealt in mains examination. These questions will be asked in mains examination. In prelims, the provisions of this Aadhaar Act becomes important. Also, money bill becomes important. Why? Because this Aadhaar bill was primarily tabled as a money bill. Although the activists say that this is not a money bill, but it is a financial bill. But nevertheless, the speaker's decision in this case is final. She said, she certified that this bill is a money bill, and ultimately Rajya Sabha, as you must be knowing, has a very limited role to play in the passage of money bill. But what is of interest right now, apart from the provisions of Aadhaar Act, money bill, please read it, financial bill, and also the role of speaker. These three issues become very important. Please read it from Lakshmikant. That should be sufficient enough from the prelims point of view. So let's look at another issue. If there are any queries, please write them. We'll take all these queries one by one after the end of this lecture. Fine? Let's look at something else. Bank Boards Bureau. What is Bank Boards Bureau? This is an autonomous body which was set up by the government under Indradhanush program. For example, you might be asked in prelims, Bank Boards Bureau was set up by the government under which of the following programs? And that is Indradhanush program. But here, please, do not confuse Indradhanush program with Mission Indradhanush. Mission Indradhanush, as you must have discussed in the India Yearbook sessions, I'll talk about it very briefly. Mission Indradhanush is a program of Ministry of Health and Family Welfare. But what is it primarily talking about? It talks about immunization. That means provide vaccines to all children for those diseases which are preventable by vaccines. For example, diphtheria, pertussis, tetanus, tuberculosis, measles, hepatitis B. That means these are 7 vaccine preventable diseases and to prevent these vaccine preventable diseases, to treat them, the government launched Mission Indradhanush. Why? To provide all these children these vaccines. So this is primarily about Mission Indradhanush. But Bank Boards Bureau was set up by Indradhanush program, under Indradhanush program, and it is an autonomous body. But what is this Indradhanush program? This Indradhanush program was started by the government to revamp the functioning of state-run banks. That means public sector banks. To revamp the functioning of state-run banks, mission or program Indradhanush was started. Under this program, Bank Boards Bureau was set up, which is an autonomous body. But what is the function of Bank Boards Bureau? There was something called Appointments Board. This Appointments Board was choosing individuals or appointing individuals to leadership positions in these state banks. For example, this Appointments Board was choosing managing directors, chief executive officers of these state-run banks. Now, this function of Appointments Board will be carried out by Bank Boards Bureau. That means Bank Boards Bureau will select these MDs and CEOs to these state-run public sector banks. Not just this. Bank Boards Bureau will also help lenders, which is these banks primarily, to raise capital, to raise money. And also, Bank Boards Bureau will develop strategies such as mergers and acquisitions. This becomes even important today because State Bank of India has said that all those associate banks of State Bank of India should be merged with the State Bank of India. Who will develop this strategy? This strategy will be developed by Bank Boards Bureau. That means what is a Bank Boards Bureau? It is primarily an autonomous body which talks about appointing members or appointing leaders to these state-run banks and also provide business strategies like mergers and acquisitions. What is the composition of this Bank Boards Bureau? It comprises of a chairperson. This is where the controversy will start. Chairperson, 3 ex officio members, and 3 expert members. What was the controversy? The controversy was that the first chairperson of Bank Boards Bureau, Vinod Rai was appointed as the first chairperson of Bank Boards Bureau, but Mr. Vinod Rai is the former Comptroller and Auditor General of India, who gave that theory that because of the spectrum allocation, the 2G licenses, the state exchequer lost more than 1,75,000 crore. And then he gave a report regarding coal scam that more than 1,86,000 crore rupees have been lost because of these scams. Vinod Rai was appointed as the chairperson, as the first chairperson of Bank Boards Bureau. But the controversy is not because of those scams, but controversy is because of Article 148 of Indian Constitution. This article talks about that a Comptroller and Auditor General cannot be appointed to any government post after the retirement. Mr. Vinod Rai retired. After that, he cannot be appointed to any government post. So how was he appointed as the chairman of Bank Boards Bureau? Nevertheless, he was appointed, and the government has justified this. Government has justified this by saying that the role of Mr. Rai as the chairperson of Bank Boards Bureau is only advisory in nature. So if it is advisory, it cannot be construed, it cannot be viewed as the government office. And it's also a part-time position. So this is all that you need to know about Bank Boards Bureau. But I will ask you a simple question which can be a potential question in prelims. I will give you a statement. For example, statement number 1, Bank Boards Bureau was set up under Indradhanush program, which is right, as we have already discussed. But second statement, RBI is not represented in Bank Boards Bureau. You know the first statement is correct, but what about second statement? You are confused. So will you attempt this question or not? That means these permutations and combinations you will have to factor in before the examination. What sort of questions can be asked? If it is Bank Boards Bureau, what is the link of RBI into this? Is RBI represented in Bank Boards Bureau or not? Yes, RBI is represented. So this statement is false. RBI is represented because the Deputy Governor, Mr. R. Gandhi, he is the ex officio member of the Bank Boards Bureau. So this is a fundamental question that can be asked in the prelims examination. But please link this Bank Boards Bureau with NPAs, non-performing assets, and also with capital adequacy ratio. Please read about these in your economy notes. You might well expect a question on these. But what about a willful defaulter? That brings us to another question, another issue that we will be discussing. Who is a willful defaulter? Vijay Mallya has been declared as a willful defaulter. That means Vijay Mallya is in the news. The NPA issue is dominating in the headlines. That means NPA is also an issue. Dr. Subramaniam Swamy says that RBI governor shall be removed or should be sacked. He should go back to Chicago. That means everything related to RBI and the banks become very important. So you should have a holistic view about all these issues. Let's talk about willful defaulter. Who is a willful defaulter? What are the costs? Who can declare somebody as a willful defaulter? And what is the another issue linked with a willful defaulter tag? Let's look at all these questions, beginning with who is a willful defaulter? Number 1, a willful defaulter is one who has the ability to repay the loans but is not paying. For example, I was given a loan by State Bank of India. I am in a position to repay the loan. That means I have assets. I have assets because of whom I can repay these loans to the State Bank of India. But I am willfully not repaying these loans despite my ability. I am a willful defaulter. Condition number 2. Now, I was given loans by various banks for Kingfisher Airlines. Let's suppose I'm Dr. Mallya. I was given loans for Kingfisher Airlines, but I'm diverting these loans to United Breweries. That means loan was meant for one specific purpose, but you diverted these loans to another purpose without informing the bank. That means you are a willful defaulter. Funds are not utilized for the purpose, but are diverted. Third, funds are siphoned off. For example, in second case here, Kingfisher Airline was given loan, but these loans were diverted to UB Group. That means at least the money is spent somewhere. But in third condition, the money is not spent on anything, anywhere, but these are siphoned off, maybe to foreign countries, maybe to private bank accounts of those individuals. We do not know. If this is what has happened, then I am a willful defaulter. Fourth condition. To get a loan from the government, I have to give some collateral. For example, a piece of land or a building. For example, Kingfisher House at Bangalore was given as collateral by Dr. Mallya. If Vijay Mallya sells that Kingfisher House without informing the bank, Dr. Mallya is a willful defaulter. That means collateral is sold off without the bank's knowledge. You are a willful defaulter. That means these are the conditions under which an individual can be declared as a willful defaulter. Condition number one, I have the ability to repay the loan, but I'm not paying back. Second, funds are not utilized for the purpose. Third, funds are siphoned off. And fourth, collateral is sold off without the bank's knowledge. But who can declare somebody as a willful defaulter? For these, we have Reserve Bank of India guidelines. Reserve Bank of India says a 3-member committee shall be set up by every bank. This 3-member committee shall comprise of executive director and 2 senior officers of the rank of general manager or deputy general manager. But you must be thinking that why are we discussing even the composition of this committee? This is not required. This is required because something has happened. 2 years back, Dr. Mallya was declared as willful defaulter by United Bank of India, Union Bank of India. Dr. Mallya went to Kolkata High Court, asking the court that how can Union Bank of India declare me as a willful defaulter? Calcutta High Court asked why. Dr. Mallya's counsel said, Reserve Bank of India says that a committee of 3 has the power to declare somebody as willful defaulter, but in the case of Union Bank of India, this committee comprised of 4 members. On this technical ground, the Calcutta High Court said, no, Vijay Mallya is not a willful defaulter because RBI guidelines say this committee, which can declare somebody as willful defaulter, shall comprise of 3 members. So forget about that. This 3-member committee will issue a show cause notice. For example, to me, why I should not be declared as a willful defaulter. Please provide us the reasons for that. After this show cause notice is given to me, I am replying back. The committee is declaring that I am a willful defaulter. But the report of this committee, very important here, the report of this committee shall be reviewed by another review committee. This report of this committee shall be reviewed by another review committee. This time it must be headed by either the chairman or the CEO and managing director of the bank. And after review committee also declares me as a willful defaulter, this tag, willful defaulter, will become final. That means preliminary inquiry is conducted by this 3-member committee. This report is then reviewed by this review committee. After review committee gives its final go ahead, I am a willful defaulter. But then, what exactly happens? What happens if someone is declared as a willful defaulter? Now, these are some of the important statements which can be asked in the examination. Number 1, the costs to an individual who is declared as a willful defaulter. Cost number one, no further credit is available. That means no further loans are available to an individual who is declared as a willful defaulter. Second, if I am declared as a willful defaulter today, for the next 5 years, I cannot float a new business. Cost number three, banks and lenders will have the right to change the management of my company. That means, one, no further credit is available to me. Second, if today I am declared as a willful defaulter, for the next 5 years, I cannot float any new business. Third, my company's management can also be changed. The banks and lenders will have the power to change the management of the company. That is the cost to an individual who is declared as a willful defaulter. Cost number four. Now I am a willful defaulter, but I am a board member of a company called Byju's. For example, now the banks will not lend to Byju's as well. Why? Because Byju's have a willful defaulter on its board. So these are the important penalties that can be imposed on an individual or a firm which is declared as a willful defaulter. But very important point to note here, at present, there is no specific law for legal action against willful defaulters. There is no specific law as such. RBI has only framed the guidelines regarding who can be declared as a willful defaulter. But banks initiate action under an act called SARFAESI. SARFAESI Act of 2002. This is something that you must have discussed in your economy lectures. That means at present there is no specific law for legal action against willful defaulters. RBI has framed rules defining a willful defaulter, but banks initiate action against such individuals under SARFAESI Act. But let's link this entire issue, because as I said, banking is in the news very recently and is dominating the headlines. Let's link this issue with something else. CIBIL, which is Credit Information Bureau, India Limited. Now, what is the CIBIL? It's a credit information company which was founded in August 2000. But what is the function of this committee? Or what is the function of this company? Here is a bank. These banks send reports to whom? CIBIL. But what are these reports? These reports contain information regarding an individual's or company's loan payments and credit card payments. That means this is a company which was founded in August 2000, Credit Information Bureau. What is the function of this committee? Banks send reports to this company. What are these reports? For example, I have been provided a loan. Am I repaying this loan at every interval of time or not? Am I providing my credit card payments in time or not? All these reports are sent to this credit information company. And based on these reports, this CIBIL creates what is called credit information report. And higher this credit information report, the much easier it becomes for you to get a credit card, the much easier it becomes to you to get a loan from a company. But this statement as such is not important, but one statement is important because RBI guidelines say that banks have to submit a list of willful defaulters to the Credit Information Bureau of India Limited at the end of every quarter. Only this statement is important, but this statement you would not have understood if I would not have explained you what is the meaning of CIBIL. That means RBI has said that banks will have to submit a list of willful defaulters to this Credit Information Bureau of India Limited as well. This is all that you need to know regarding the Bank Boards Bureau, willful defaulter, and CIBIL. Now let's look at another issue. The issue is Prithvi 2 missile has been test fired. Now what is a Prithvi? Who has launched Prithvi? What are the specifications involved and other associated issues? Let's have a look at them one by one. But first up, there are 3 versions of Prithvi. Prithvi 1, Prithvi 2, and Prithvi 3. Prithvi 1 is an army version. Prithvi 2 is an air force version. And Prithvi 3 is the navy version. But this naval version has the highest range of 350 kilometers. Air Force has range of 250 kilometers. And Army version of Prithvi has the range of 150 kilometers. But who has developed these Prithvi? These are developed by DRDO under a program called Integrated Guided Missile Development Program. Integrated Guided Missile Development Program. This program was started in 1983. Now, what was the objective of the scheme? The objective of this scheme was to make India self-sufficient. Not make in India, but to make India self-sufficient. Self-sufficient how? Self-sufficient in the production and development of wide range of ballistic missiles. That means under IGMDB, DRDO has launched these Prithvi missiles. But what are these Prithvi missiles? 2 important statements here. Number 1, they are surface-to-surface missiles. And at the same time, they are capable of carrying nuclear warheads. They are nuclear capable magazines or missiles. Fine. That means Prithvi 2 was launched. This is in the news. We need to understand about Prithvi 1, Prithvi 2, Prithvi 3. The highest range is that of Prithvi 3, which is a naval version. All these Prithvis were launched by DRDO under a program which was started in 1983 called IGMDB, and Prithvi is a surface-to-surface missile and a nuclear-capable missile. Not just this. There is also a talk that's what makes Prithvi very important from the examination point of view, that Prithvi 1 might be replaced, withdrawn, and replaced by something called Prahar, which is another surface-to-surface missile. Fine? Let's look at something else related to Prithvi. Now, Prithvi is developed by DRDO, but Prithvi is deployed by Strategic Forces Command. What is this Strategic Forces Command? If we ever take a decision to launch a nuclear attack, let's say we take a decision to launch a nuclear attack on Pakistan, who will take that decision? That decision will be taken by NCA, which is called Nuclear Command Authority. Nuclear Command Authority is headed by Prime Minister. That means the decision to launch a nuclear strike will have to be always a political decision. That means if we ever take a decision to launch a nuclear attack, that decision will be taken by Nuclear Command Authority. But once the decision is taken by Nuclear Command Authority, Strategic Forces Command comes into play. And this Strategic Forces Command will be the sole authority responsible for selecting the target. Selecting the target of nuclear attack as well as deploying nuclear weapons. That means Strategic Forces Command will be the sole authority to determine on what target shall we launch this nuclear attack, and this Strategic Forces Command will also be responsible to deploy these nuclear weapons at the site. This is all that you need to know about Prithvi. Let's look at something else. Which of the following are characterized as near threatened by IUCN? Option 1, Himalayan griffon. Option B, falcated duck. Option C, Amur falcon. Now this is something that every aspirant is asking. Do we have to memorize all the names of those species who are near threatened, extinct, endangered? How can we memorize the names of all these species? It's not possible. Yes, clearly it's not possible. But what is possible? If there are some species which are in the news, please make note of these species. Also note down their IUCN status and some important features. This is where you will get all these questions right in your prelims examination. That means all these three species were in the news. That is why I'm asking this question. But if you look at the status, only Himalayan griffon and falcated duck are characterized as near threatened. Amur falcon is characterized as least concern. But to understand fully what these species are all about, Let's talk briefly about all these three species, because these three species are very important from the examination point of view. First, let's look at Himalayan griffon. The first question is, what is the Himalayan griffon? Himalayan griffon is basically a vulture which belongs to the family called Accipitridae. That means it's a family of small to large birds. Himalayan griffon is a vulture which belongs to the family of small to large birds called Accipitridae. But where is this Himalayan griffon found? Primarily, it is found in Himalayas, but very recently it was spotted in Goa, which is very, very, very rare. That's what makes it important from the prelims point of view this year. Usually found in Himalayas, but recently spotted in Goa, which is very, very rare. But what is something exciting about these, unique about this Himalayan griffon? Unique thing is, number one, Himalayan griffon do not breed in the first 3 years. Ornithologists means those who study birds. Ornithologists say that Himalayan griffon is the largest and heaviest bird which is found in Himalayas. And as I said, what is the IUCN status of these Himalayan griffon? It is near threatened. But where is this threat coming from? If you look at 2012 question paper, the question asked was, mostly we used to see large number of vultures in the sky of Delhi, but over a period of time, the number of vultures have decreased. What do you think is the reason? Similarly, the same danger is for these Himalayan griffon. And what is the reason? The reason is diclofenac. Diclofenac is primarily an anti-inflammatory drug. This drug is given to the livestock. That means buffaloes, cows, etc. But because of the feature of diclofenac, it is not fully consumed by these livestock. So it remains as a residue in their bodies. Once these livestock are dead and these vultures feed on these dead carcasses, ultimately diclofenac enters into their bodies as well, and they ultimately die. This diclofenac is one of the principal reasons why Himalayan griffon is near threatened currently. Fine? Let's look at something else. Falcated duck. Because these environment and ecology and science and technology questions are the dominant theme of prelims examination over the past few years. So these environment related questions are very, very important to understand, and this is how you should link them. What are these falcated ducks? These are primarily migratory birds. They breed in Russia, North China. The names of these countries you need not to memorize. This is just to explain. Falcated ducks are migratory birds. They breed in Russia, North China, etc. But when the weather turns extreme, they migrate, and some of them come to India. But which part of India? Northern India. The UP Bihar belt. That means primarily these migratory birds do migrate to India, but they are predominantly found in northern India. But in February 2016, these falcated ducks, in February 2016, the month of which current affairs we are discussing, these falcated ducks were spotted in Goa, which again is very, very, very rare, and that makes it a potential question in your prelims examination. Another important point. Normally, DNA is found in the nucleus of a cell, right? But in falcated ducks, DNA is found in mitochondria. Another important statement regarding falcated duck and the status, the IUCN status of falcated duck is near threatened. Let's look at another bird, Amur falcon. Amur falcon is a small raptor. Now, what do we mean by raptor? Raptor basically means birds of prey, which means these birds hunt and feed on other animals. The unique thing about this Amur falcon is their vision. Their vision is so sharp that they can detect a prey during their flight also. Such is the powerful vision of these Amur falcons. Another important thing is you can easily distinguish between a male and a Amur falcon. Just like Bharatnatyam. Bharatnatyam, a classical dance of India, whenever on a stage Bharatnatyam is performed, by looking at the costumes of these characters, you can easily depict who is a hero, who is a villain. That means by looking at the costumes only, you can depict which character this individual is playing. Similarly, by looking at these Amur falcon, you can easily distinguish between a male and a female. Males are dark gray, and females have dark scaly markings on white underparts. That means basically the body is white, but on this white body there are dark scales of gray. But male Amur falcon is clear dark gray. This is how you distinguish them. These Amur falcons are also migratory birds. They breed in East Asia, primarily Siberia, and then they migrate to India. Now look at this very interestingly. This is where it starts getting very interesting. They come to Nagaland. From Nagaland, they migrate to South Asia. From South Asia, they migrate to Mongolia. And from Mongolia, they come back to Nagaland. But why is this pattern important? Why are we wasting our time to discuss this pattern? Nagaland to South Asia to Mongolia, back to Nagaland? Because to understand this pattern, to prove whether these Amur falcons migrate in this fashion or not, scientists in India tagged 3 Amur falcons with satellites. And 2 of these Amur falcons are now back in Nagaland. That's very important statement. The tagging, scientific tagging of satellites with these Amur Falcon, a very important statement from the prelims point of view. But the most amazing thing about these Amur Falcon is the 3.5-day flight across the Arabian Sea. And remember, this is a non-stop flight. Now, what is the IUCN status of Amur Falcon? It is least concern. Thanks to their breeding pattern, because these Amur Falcons breed ferociously, there is no decline in the numbers of Amur Falcon. They are predominantly present throughout the world. Now let's look at another issue. I will ask you a question and you please answer it. Consider the following statements. Number one, International Fleet Review 2016 was conducted by UN at Seychelles. Statement number B, 7th Indo-Seychelles Joint Training Exercise was conducted at Visakhapatnam. This is how the questions are usually framed by UPSC. Consider the following statements and which of the following statements are correct. And if you need the answer, both these statements are wrong. But I framed this question to understand and discuss two important topics: International Fleet Review 2016 and 7th Indo-Seychelles Joint Training Exercise. Let's look at them one by one. Beginning with International Fleet Review 2016. This International Fleet Review was not conducted by United Nations, but it was conducted by Indian Navy. It was not conducted at Seychelles, but it was conducted at Visakhapatnam. And remember, at Visakhapatnam, we have our Eastern Naval Command. Close to 52 countries participated in this International Fleet Review. But what was the objective? Why was this fleet review conducted in India? The objective was to improve mutual trust and confidence. To improve mutual trust and confidence between the participating nations, and at the same time to depict war readiness, whether these navies are ready for the enemy onslaught or not. How prepared are they for war? To show that, to depict that, this International Fleet Review was conducted in Visakhapatnam by Indian Navy. But something related to this. If I were to ask you, or UPSC were to ask you in prelims, match the following. Mac Campbell, US, PLAN Sania, not the Sania Mirza, China, HMAS, Darwin, Australia. Which of the following are correctly matched? All these are correctly matched. But what are these? These are warships of US, China, and Australia, which participated in this International Fleet Review 2016. So that makes this another important question which can be asked by the UPSC in prelims examination. Let's turn on to 7th Indo-Seychelles Joint Training Exercise. This joint training exercise has also been termed as Exlemity. And this joint training exercise was conducted at Mahi Island in Seychelles. It was a joint training exercise between India and Seychelles. But what was the aim? The aim was to improve the coordination of both the armies in fighting terrorism. This brings us to the closure of another important issue, International Fleet Review and 7th Indo-Seychelles Joint Training Exercise, which was conducted at Seychelles. And this is the 7th Joint Training Exercise, and it's also called Exlemity. Let's look at another issue. Prime Minister Modi declassified files, 100 files, pertaining to Netaji Subhash Chandra Bose. Trinamool Congress head and Bengal Chief Minister Mamata Banerjee also declassified some files. But these files did nothing to bury the myth that Netaji was in India after independence. Some say he was in India as a sadhu in Allahabad in UP. Some say that he did not die in the plane crash. But nothing was done to bury this myth and to tell us what exactly happened with Netaji Subhash Chandra Bose. But that is not our concern. Our concern is how the files are classified in this country. What is the sensitivity of the information? If the information is disclosed, will it affect our national security or not? Or will it cause exceptionally grave damage or simply damage? If the release of the information causes exceptionally grave damage to India's interests, or it causes simply damage to India's interest, on the basis of these sensitivities, the files in India are classified as top secret, secret, confidential, and restricted. If the information causes exceptionally grave damage to India's national security, if the information, if it is leaked, causes exceptionally grave damage to India's national security, that file is called top secret or classified as top secret. If the information which is leaked will cause serious damage to India's interests, that file is classified as secret. If any information, if it is leaked, embarrasses the government, that file is a confidential file. And if the information is meant for only official purposes, that file is classified as restricted. But how can we say whether an information will cause exceptionally grave damage, or whether it will cause serious damage, or whether it will embarrass the government? How do we know this? How can we quantify this? The answer is we cannot know about that. That is why these files have been classified as top secret, secret, confidential. But we have some hints as to which files are top secret, which files are secret, which files are confidential. For example, December 2015, Foreign Policy magazine, which is a very important foreign policy magazine. Foreign Policy magazine carried out a news item. This news item was, India is building a top secret nuclear city to produce thermonuclear weapons. India is building a top secret nuclear city to produce thermonuclear weapons. Where is the city? If the information is disclosed, it will cause a serious, exceptionally grave damage to India's national interest. That is why this file is a top secret file. Similarly, for example, there have been talks that India played a very important hand in dismantling the Rajapaksa government in Sri Lanka, and the RAW, which is Research and Analysis Wing, which is the external intelligence agency of the government of India. It played a very important role in the defeat of Rajapaksa. If this information is right, we do not know. But if this file, which contains the information regarding that, if this is leaked, it will embarrass the government of India. That is why this file is a confidential file. That means we know that there are 4 types of files classification: top secret, secret, confidential, restricted. But the question is, who decides this classification? These matters are decided in accordance with departmental security instructions. And these departmental security instructions are issued by Ministry of Home Affairs. But now you will ask me, what is the criteria of such classification? I will tell you the answer. I don't know. Why? A right to information petition was filed asking the Ministry of Home Affairs, asking the MHA about what is the criteria of such classification. How do you classify files based on these criteria? The MHA said, no public interest will be served if this criteria is made known to the public. The response to this RTI was, no public interest will be served if this criteria is made known to the public. That means when I gave you the example of that thermonuclear weapon city or the Indian interests or Indian role in the Sri Lankan elections, these are hypothetical situations that I'm giving you, because MHA has till now not disclosed how they classify files based on their sensitivity into top secret, secret, confidential, and restricted. But the question is, Can we ever know about such files or such information? Some of them, yes. How? Declassification. Now, what do we mean by declassification? A review of documents is done every 5 years. And normally, those files which are more than 25 years old, these files are declassified and these files are sent to National Archives. And in the archives, you can go, dig the information, view the information, and select the information. That is your choice. What that means, can we know about these files? Some of them, yes. How? Declassification. What is declassification? Primarily, it involves review of documents. That means after every 5 years, the review is done, and normally the files which are more than 25 years old, they are declassified, transferred to national archives. But can government refuse to disclose the information or to declassify a file, to refuse to declassify a file even after 25 years? Yes. For example, hundreds of files have been transferred from Prime Minister's office, from Cabinet Secretariat. Hundreds of files have been transferred to National Archives. But the files which were marked as nuclear test at Pokhran 1974, these files were retained by the Prime Minister's office. That means even after 25 years, there will be some information, sensitive information, extra confidential information, which may or may not be divulged, which may or may not be declassified, which may or may not be made known and available to the people of this country. But another issue is, who knows about the contents of these documents or these files? Politicians, some ministers, yes. Bureaucrats, clearly yes. What if a bureaucrat releases this information, leaks this information? He will be charged under Official Secrets Act 1923. This Official Secrets Act is also very important from this year's examination point of view. Why? Because we saw a woman intelligence officer of India. She was honey-trapped by a Pakistani intelligence officer. She fell into a relationship with this Pakistani intelligence boy. Ultimately, a relationship developed and she leaked sensitive information to this Pakistani intelligence guy. The case is pending against her. But the question can be, what is the maximum punishment under Official Secrets Act? And maximum punishment is 14 years. This is sufficient enough from the examination point of view. But one important point which may be asked, and that is, Second Administrative Reforms Commission, which was headed by Veerappa Moily, who was former law minister as well. This Second Administrative Reforms Commission submitted a report which was named Right to Information, Master Key to Good Governance. This report recommended that this Official Secrets Act should be repealed. That's all I think that you need to know, but as of now, this report has not been accepted by the Government of India. Official Secrets Act continues to remain in place. But regarding Netaji, Since Netaji is in the news, please read about Netaji. You might expect a question in modern history. And if you have India's Struggle for Independence book by Bipin Chandra, please read the chapter Crisis at Tripuri. And please also read about Indian National Army trials. This is all that you need to know about these Netaji files. Let's look at another issue. And let me ask you a question. Which of the following have been endorsed with India handloom tag? A. Chettinad sari. B. Banarasi brocade silk sari. C. Tanchoi silk sari. D. All of these. But why this question? If you look at previous year's prelims paper, you were asked about Tirupati Laddu. Because Tirupati Laddu was conferred with geographical indication, GI tag. Because it was in the news, that is why this question was asked. This year, in February, we saw Chettinad sari was endorsed with India handloom tag. So which of the following have been endorsed with India handloom tag? This can be a potential question in your prelims examination, and the answer is all of these. But the question is, if the answer is all of these, the question should be, what is the significance of this India handloom tag? Suppose you want to buy an authentic handloom product, but there are various fictitious products present in the market. You do not know whether these products are authentic or not. And the government has come into picture. The government's endeavor or the effort is to save and survive or to help these handloom industries in this country. Because since new players are entering into the market, they are proliferating the market with false and duplicate products, cheap products. Ultimately, the name of Indian handloom is going down. To protect the name of Indian handloom, the government says, we will provide India handloom tag. And if any product is endorsed with India handloom tag, that means a customer should not worry about the authenticity of that product. That product will definitely be a judgmental, a very authentic handloom product of India. That means this tag is given only to authentic handloom products so that customers can feel assured about the quality of such products. Let's look at another issue. Photonic propulsion. As I said, environment-related questions and topics, science and technology-related topics, these are the dominant themes of prelims examination. So let's talk about photonic propulsion. Later on, we'll also talk about gravitational waves. These were very important news items these months. A group of researchers from the University of California, Santa Barbara. This group of researchers is working on a new way to travel in space. And this new way is called photonic propulsion. What is photonic propulsion? This photonic propulsion uses lasers. And if this experiment works, if this research works, it can take us to Mars in 3 days, and will also be used to explore other stars. But since it is a research, the project is called Deep In. The name of this project also becomes important. Why? Because if you look at last year's prelims examination, the question was asked about Ice Cube, a neutrino observatory. So Ice Cube question was asked. Today, Deep In can be asked. So Deep In is a project of a group of researchers who are working on this photonic propulsion, which uses lasers, and if it is successful, it can take us to Mars in 3 days. But what is primarily this photonic propulsion? The goal of this project is to use electromagnetic acceleration. These days, if we look at our spaceships, we do not use electromagnetic acceleration, but we use chemical acceleration. But what is chemical acceleration? That means primarily the fuel is burnt. When this fuel is burnt, it releases chemical energy, and because of that energy, the spaceship is moving forward. That is what is called chemical acceleration. These spaceships which use chemical acceleration, they are fast. Yes, they are fast. But they are just not fast enough to travel to other stars in any reasonable amount of time. Why? Let's not forget about Voyager 1. Voyager 1 has just left the solar system. But do you know when it was launched? It was launched in 1977. That means the problem is clear. We cannot reach other stars with rocket fuel alone. We need something else. If we have to reach to outer space, other planets in the outer space very fast, that means we have to do away with chemical acceleration and move towards something called electromagnetic acceleration. And this electromagnetic acceleration, it does not use chemical energy, but it uses electromagnetic radiation, or more specifically, it uses the energy from a huge set of lasers, and these lasers are powered by sunlight. Now, I know some of you who do not have a science background, they will be confused. So for those individuals, let's try and explain it in slightly layman's language. The rationale is that light has a lot of pushing power. The light has a pushing power to push this spaceship into the space. That means chemical acceleration, which uses fuel, that also causes acceleration in a ship. But instead of that, why not use light? Because light has a lot of pushing power, which push the spaceship into the space. And where is this pushing power coming from? It is coming from momentum. To explain it further, photonic propulsion works by firing lasers. Now, where are these lasers fired? These are fired on solar sail. This principle is not important from the examination point of view, but just to understand the concept, I'm explaining this. Photonic propulsion fires lasers on this solar sail. But this solar sail is primarily a reflective material. So light will be reflected. That means light, a packet of light is called photon. Photon will be reflected. But photons do not have mass, but they do possess energy and momentum. Assume something without mass, but with energy and momentum. That means these photons will transfer kinetic energy to this reflective surface, and ultimately the spaceship will be moved forward. Because let's not forget, we are in space, and space is frictionless. That means acceleration will continue and spaceship will be forward. Let's not also forget that there are hurdles. That is why the research is going on. And that is why I said if this research is successful, if photonic propulsion is successful, it can take us to Mars in 3 days. But from examination point of view, 2 things are required. Number 1, what is this project deep in? This is a project which talks about photonic propulsion. And photonic propulsion uses electromagnetic acceleration and not chemical acceleration, which is used by our present day spaceships. Fine? Let's look at another issue. Consider the following statements. Number 1, the ruling of the United Nations Working Group on Arbitrary Detention is binding on all the member countries of UN. And number 2, United Nations Working Group on Arbitrary Detention comes under Security Council. Why is this UN Working Group on Arbitrary Detention is in the news? We saw Julian Assange, the founder of WikiLeaks. He is currently inside Ecuador embassy. Why? Because he is accused of a sexual assault case, and he is wanted by the police in Sweden and also by the England authorities, Scotland Yard. But since he is inside the Ecuador embassy, the police cannot enter this embassy without the permission of the head of the mission. Because under Vienna Convention on Diplomatic Relations, Article 22 of that, the embassy is inviolate. It cannot be entered into by any police without the permission of the head of the mission. But Julian Assange filed a petition, a case before UN Working Group on Arbitrary Detention, telling the UN group that basically I'm not here based on my own likeliness, but I'm here because I'm under arbitrary detention. I am unreasonably detained by England authorities in Ecuador embassy. This matter was heard by UN group, and UN group declared, yes, Mr. Julian Assange is under arbitrary detention and he must be released. But the fact is, the ruling of this UN Working Group on Arbitrary Detention is not binding on the members of United Nations. And at the same time, this working group, it does not come under United Nations Security Council, but it comes under United Nations Human Rights Council. Now, what is the function of this UN Working Group on Arbitrary Detention? It consists of independent human rights experts to find out whether the international human rights law is violated or not. Important thing is that it investigates these cases of arbitrary detention because it consists of various independent human rights experts throughout the world, but ultimately it's a toothless body in the sense that its decision or verdict is not binding on the member countries of United Nations. Let's look at another issue. This time, Section 124A of Indian Penal Code, which is a sedition law. This sedition law has been explained fully in one of our YouTube videos. Please go through our YouTube videos and you will find out this JNU controversy and Section 124 capital A of Indian Penal Code dealing with sedition. And after that, you don't need to read anything from any book. But very briefly, there is freedom of speech and expression. But this freedom of speech and expression is not absolute. It comes under reasonable restriction under Article 19, Clause 2. What are these reasonable restrictions? Such as contempt of court, defamation, sovereignty of India, right? But sedition is not a reasonable restriction. A very important statement. Sedition is not a reasonable restriction under Article 19, Clause 2. It's not a reasonable restriction under which your freedom of speech and expression can be curtailed. Statement number 2. Tilak was arrested under sedition law when he was still a member of Bombay Legislative Council. In 1897, when Tilak was arrested, he was still a member of Bombay Legislative Council and he was sentenced to a jail of 6 years for sedition because he directly or indirectly justified the killing of Rand brothers, just the killing of Rand by the Chapekar brothers, because Rand was the Plag commissioner at that point in time. So this is an important statement which can be asked in your prelims examination. But at the same time, in 1897, Tilak pleaded innocent. That means he pleaded before the court that I'm not guilty of sedition. But at the same time, if you look at Mahatma Gandhi in 1922, he was also charged with sedition, but in 1922, he pleaded guilty. He pleaded guilty to sedition. That means the best thing that an individual can do right now is to promote disaffection against a government which promotes discrimination. These are the words of Mahatma Gandhi. So sedition law, which was in the news throughout these 2 months of February and March, a very important issue, but this issue has been explained fully in one of our YouTube videos. Please go through that. But these 3 statements are very important. 1, sedition is not a reasonable restriction under Article 19, Clause 2. 2nd, Tilak was arrested under sedition when he was still a member of Bombay Legislative Council. And while Tilak pleaded innocent in 1897, Gandhi pleaded guilty in 1922 and said, yes, I am guilty of sedition. Let's look at another issue. The issue which deals with a controversial event which was conducted or held by Art of Living Foundation by Sri Sri Ravi Shankar. An Indian cultural event, an international event where dignitaries from various countries participated, which was inaugurated by Prime Minister Modi as well. But this Art of Living became a controversial event, and ultimately National Green Tribunal slapped a fine on Art of Living Foundation. Now we will talk about this controversy, but first up, let's talk about National Green Tribunal. National Green Tribunal was set up under National Green Tribunal Act of 2010. Why? Why was it established? It was established to quickly dispose of cases relating to environmental protection. NGT was established under NGT Act 2010. The objective was to quickly dispose of cases related to environmental protection. That means any case relating or regarding the environment will go to NGT so that the environment is saved and quick justice is delivered. Not just about environment, but also about conservation of forests. These cases also come before NGT. Not just about conservation of forests, but conservation of other natural resources as well. But when NGT gives an award or gives a verdict, is it binding or is it not binding? The NGT Act says it is binding. But if you are not satisfied with this verdict given by NGT, you can approach the Supreme Court of India. Because Section 62 or 22 of the NGT Act makes it clear that if you are not satisfied with the award or the verdict given by National Green Tribunal, you can directly approach the Supreme Court. This is about National Green Tribunal. But what about the controversy? Art of Living was accused of practicing something called enzyme technology. It was accused of practicing enzyme technology in the Yamuna River. But what is enzyme technology? Some enzymes are introduced in the river with the intention, with the purpose of cleaning the river. These enzymes, Art of Living says, are eco-enzymes. But environmental activists say that these are not eco-enzymes, but these are garbage enzymes. But first up, what are enzymes? Enzymes are basically organic chemicals which help break down other chemicals. For example, in human body, we eat food because there are enzymes which are present in our mouth, in our stomach as well. These enzymes are released. They break down the food into various particles so that digestion becomes possible. In case of pollution, or in the context of pollution, these enzymes break down these pollutant molecules, either making them less harmful or making them easier for marine life to eat them up. That means in the context of pollution, these enzymes are doing something like making these pollutant molecules less harmful or dividing them into various constituents so that it becomes easier for the marine life, such as the fishes, to eat them up. But what is this garbage enzyme? How is it prepared? Garbage enzyme is prepared by, although this composition is not required, but something related to this is required. That I will tell you what that is. It is prepared by mixing 1 part of jaggery or brown sugar, 3 parts of kitchen waste. What is a kitchen waste? Basically vegetable remains or leftover food of the previous night. These are kitchen waste. And these things are mixed with 10 parts of water. And this entire mixture is kept sealed for 3 months so that fermentation takes place. This is what is important. Ecoenzymes or garbage enzymes, the production of these enzymes involve which of the following processes? The answer is fermentation. This can be a potential question in your examination. But once this part of jaggery, when this mixture is kept sealed for 3 months, fermentation takes place. An Art of Living members say 1 liter of this liquid, of this mixture that is contained now, is capable of treating 1,000 liters of polluted water. But you will tell me that since Art of Living is doing such a fabulous thing, why is there a controversy? We must support it, encourage it, because our rivers, our water bodies are polluting day by day. So such innovative measures must be supported. But this is how or where we need to be extra vigilant. Let's not forget there is a problem. And the problem is that this experiment which Sri Ravi Shankar is saying they have conducted, it is not scientifically tested. And if it is not scientifically tested, it goes against an act made by the parliament. And that act is Water Prevention and Control of Pollution Act 1974. This act makes it absolutely clear that you cannot introduce foreign elements into water bodies without any scientific study. Since ecoenzymes or garbage enzymes, no study has been conducted as of now to prove whether they are efficient or not. Since no study has been conducted, it goes against the Water Pollution Control Act 1974. Another issue. Let's not forget, if Yamuna is in the news, can you tell me which of the following is not a tributary of Ganga? Because Yamuna is a tributary of Ganga. Which of the following is not a tributary of Ganga? Yamuna, Son, Gomti, Tista. The answer is Tista, because Tista is the tributary of Brahmaputra. That means what is important in the news, what is happening in the news? Art of Living Foundation organizes an event. This event has been criticized because NGT imposed a fine and environmental activists cried that what Art of Living is doing in these Yamuna rivers, it is unscientific. And what was the reason to conduct this event in Yamuna, on the banks of Yamuna in the first place? Why not do it somewhere else? So that is the issue. Everything related to this issue we have covered, and you don't need to see and go through any other material whatsoever. Another issue which was in the news, if you look at section 377 of Indian Penal Code, which talks about unnatural offenses, and which, in a sense, criminalizes homosexuality. This topic was in the news. Why? Because in December 2015, Dr. Shashi Tharoor, a two-time parliamentarian from Thiruvananthapuram in Kerala, he introduces a private member bill asking the parliament, let's delete section 377 from Indian Penal Code. This bill was not even allowed to be tabled in the parliament. But then the Supreme Court set up a constitution bench, or referred this matter to a constitution bench when a curative petition was filed. And now people say this is the last hope. If this curative petition is accepted, if the verdict goes in favor of LGBT community, then this is a landmark event in the history of India. But if it is defeated in the Supreme Court, only an act of parliament can come to the rescue. So section 377 was important because in February, Supreme Court referred this matter to a constitution bench. But on section 377, I have made a detailed lecture on YouTube. Please go through our YouTube lecture and you won't be required to read anything else on section 377. Fine. Let's talk about something else. India's solar panel dispute. Are you tired? Anyone who needs a break may raise their hands. Just 2 people. Okay, so we'll continue. Let's first look at the background. India launched Jawaharlal Nehru National Solar Mission. This program was launched in 2010. But what was the purpose of this mission? What was the objective of this mission? The objective of this mission was to establish India as a global leader in solar energy. This was the objective of this national solar mission. To achieve this objective, to achieve this purpose, the government said, let's do this. And what is that? The government said, let's enter into a long-term power purchase agreement. When I say long-term, it means 25 years. The government said to achieve our objective of making India a global leader in solar energy, let's enter into a long-term power purchase agreement with whom? With solar power producers. And what will happen because of this? These solar power producers will produce power. This power then will be purchased by the government. That means government is guaranteeing that you, dear solar power producers, you purchase the power, you produce the power, and we will purchase this power. You produce power, we will buy that power, and we will tell you before you begin production what will be the price of the power produced. But what will be the impact of this? The impact is, if I'm a businesswoman, I'll invest in solar power because I have been given a guarantee that government will buy my power. So I'm happy. And the goal of JNNSM, Jawaharlal Nehru National Solar Mission, is to make India a global leader in solar energy. That will also be achieved. The government will sell this power to the customers, which is you and me. But ultimately what will happen? Because of these power purchase agreement, some guarantee will be provided to these solar power producers that you produce the power and we will purchase this power. and we will give you a good amount of money for that. And this agreement is for 25 years. But there is a catch, a condition which the government is putting, or which the government said you will have to adhere to. In order to become eligible for this power purchase agreement, you will have to satisfy something called domestic content requirement, or DCR. What is this domestic content requirement? Dear businesswoman, if you want to be eligible for this power purchase agreement, then what you will have to do when you create a solar plant, the material that is required, the modules that are required, those material, solar cells, modules must be domestically produced. And this will also help in Make in India. That means in order to be eligible for this power purchase agreement for 25 years, what you will have to do, you will have to satisfy this domestic content requirement. That means the solar cells and modules that are used solar projects, they have to be domestically or locally manufactured. If they are not, government cannot guarantee the purchase of energy produced. Very good. For us, it's a win-win situation. Make in India, very good. 2013, United States complained before World Trade Organization, complaining that this domestic content requirement is violating General Agreement on Trades and Tariff, GATT, and it's also violating Agreement on Trade Related Investment Measures, TRIMS. Domestic content requirement, you know. Long-term power purchase agreement, you know. But if you do not satisfy these domestic content requirements, the government cannot guarantee that the power you produce will be purchased by the government. United States goes to World Trade Organization saying India is violating GATT and TRIMS because of these domestic content requirements. Then why? That means India has violated something called national treatment, which I hope you must have read in your economy lectures. Your economy faculty must have discussed this. National treatment obligation, basically violation of this means that India is discriminating against imported solar cells and modules. That means you are discriminating between those cells which are locally produced and those cells which are imported from other countries. That means you are violating this national treatment, and which goes against GATT and TRIMS. Ultimately, WTO gave its verdict, and the verdict was in favor of United States. When the verdict was in favor of United States, but here are the statements which are important from the prelims point of view. One, DCR is related to Jawaharlal Nehru National Solar Mission. Fine. The panel ruling of WTO is not final. India has shown its willingness, and India has ruled that we will appeal against this order before an appellate body. So these are the important statements from the prelims point of view that can be asked in your prelims examination. Let's look at another issue. The issue is real estate law. This real estate bill, which was passed in March 2016 by the Rajya Sabha. Very briefly, although questions on bills are not primarily asked in prelims examination, but very briefly, 2 or 3 statements I will tell you, and that should be sufficient enough from the prelims point of view. This real estate bill talks about the establishment of state level regulatory authorities. State level regulatory authorities, which are called real estate regulatory authorities. But what exactly is the implication of this real estate bill? For example, I purchased a flat by a good developer. This developer is telling me that by 2017, you will be getting the possession. Fine. But I purchased this flat on a loan. I am providing EMIs to these banks as well. What if by 2017, this possession was not given to me? The possession of this flat was not handed over to me. That means A, I am providing EMI to the bank for the flat where I am not living, and at the same time, I am providing rent of the flat where I am currently residing. This real estate bill says, if a project developer is not able to complete the project in time, then the interest of the EMI and the EMI will not be paid by the consumer, but will be paid by the developer. That means the law ensures that any delay in project completion will make the developer liable to pay the same interest as EMI as it is paid by the consumer to the bank. And the consumer, who was paying interest, who was paying EMI to the bank, that EMI and that interest will be paid back to this consumer. That means ultimately the onus of completing the project will lie before the developer. Second important statement. What happens because of this is that consumer confidence is increased. The consumer will know that the project will be completed in time so that they can make their own plans and programs, and ultimately their confidence in the regulatory framework increases. But what about defects? We see whenever a project is handed to us, within few years, defects take place. The defects become known to the individual. Initially, what was happening, if the defects arose in the period of 1 to 3 years, the liability will be that of a developer. That means whatever defects take place in 1 to 3 year period, when this project is given to you, if there is any defect, all the cost will be borne out by the developer. But this real estate bill talks about, now this liability will extend to 5 years. That means within 5 years, when this project was delivered to you, even if there are some defects which arise, the responsibility, the onus will lie on the developer, and developer will rectify all those defects. These are some of the very important statements that are required from the prelims point of view. And that brings us to the end of this another issue. Let's talk about something else. This is the last issue that we will be discussing now. And it talks about gravitational waves. Scientists announced the discovery of gravitational waves. But what are these gravitational waves? Primarily, these gravitational waves are ripples in the space. And these ripples in the space were first anticipated by Albert Einstein. Fine. But how did scientists detect this? They detected these gravitational waves because of the fusion of two giant black holes. The fusion of these two giant black holes created ripples in the space, these ripples which we call gravitational waves. And the scientists detected this. But how did the scientists detect this? They detected this by using an advanced LIGO, what is called laser interferometer gravitational wave observatory. That means what happened? Scientists announced the discovery of gravitational waves. And what are these? Gravitational waves are ripples in the space which were first anticipated by Einstein. But how did scientists detect this? They detected this because the fusion of two giant black holes took place. And how? Using an advanced LIGO. But let's look at this from the examination point of view, from the UPSC point of view, and not from the physics or gravitational astronomy point of view. According to Einstein and his theory of relativity, the space-time is not void. Space-time is not void, but the space-time is rather a four-dimensional fabric. And this fabric can be pushed or pulled as the objects move. And when this fabric can be pushed or pulled, when the objectives move through it, these objects called distortions when the objects are moving, and these distortions are the real cause of gravitational attraction. But for non-science students who are still confused about what do we mean by this fabric, let me explain it from a layman's perspective. For example, let's take a rubber sheet. Rubber sheet, that means it's a fabric, that means it's a space-time. Let me place a heavy object on this. Since it is a rubber sheet and I'm placing a heavy object on this, what will happen to the space underneath this heavy object? It will bend, or to use a specific term, there will be sagging. Fine? But there will be bend because this object is thrusting this fabric beneath. What if I place a smaller object here? What will happen to this object? This object will fall into this place and there will be fusion. This is exactly what is happening in this space. Two objects are moving together. When these two objects are moving, suddenly there is a collision, there is a fusion, and these fusions create ripples in the space. And these ripples are gravitational waves. But I am saying this from a layman's perspective because this is a small object. But the fusion of two small objects do not cause gravitational waves. For gravitational waves to occur, the fusion has to be between two incredibly massive objects. That is why we say the fusion of two giant black holes produce gravitational waves, which were detected by the LIGO. But how LIGO detects it? This LIGO uses an instrument called interferometer. This interferometer sends a laser beam When this laser beam is sent, interferometer splits this laser beam into two. That means these two laser beams, which are going through the space, if they do not encounter anything in the space, they will come back. But they will come back with the same length. That means length of these laser beams will not change. But if they encounter gravitational waves, there will be distortion in their lengths. And this distortion is then measured by LIGO, and this is how they detected the presence of gravitational waves. But since, if you look at 2013 question paper, the question asked was Higgs boson. Higgs boson was discovered at that point in time. And the question was, the discovery of Higgs boson will help in which of the following cases? So if similar question is repeated today, how will the detection of gravitational wave help us? 2-3 points. Gravitational waves will help us to understand the life and death of stars. They will help us to understand a little bit more about how the universe was formed. As I said, we can detect gravitational waves when black holes collide, right? That means gravitational waves detection can also help understand the events which produce these stars. That is one of the most remarkable things that can happen because of the detection of these gravitational waves. But what is the Indian connection here? There are many LIGO observatories in different parts of the world, but as of now, there are only 3 advanced LIGOs. Or should I say there are only 2 advanced LIGOs. 2 advanced LIGOs are currently, because of which we detected these gravitational waves. Because normal LIGOs do not detect, we require the advanced LIGOs. These 2 LIGOs or advanced LIGOs are both present in United States. One is in California Institute of Technology, and the other is Massachusetts Institute of Technology, both in United States. But the world's 3rd advanced LIGO, that means world's 3rd advanced laser interferometer gravitational wave observatory, will be set up in India, and it will become operational by the year 2023. This is the most remarkable thing that can happen in the history of Indian astronomy, and this will give a huge fillip to the research which is conducted in this country. That means there are 2 advanced LIGOs in the world, one in California Institute of Technology, what we call Caltech, the other at Massachusetts, and the 3rd advanced LIGO will be set up in India by the year 2023. This is all that you need to know about gravitational waves, and this completes our current affairs roundup of the months of February and March. And let me reiterate, this is excluding economic survey, for which you will have a separate discussion. This is excluding the general and the railway budget, for which also you will have an exclusive session. This is all that you need to know. Thank you for watching. Any questions? Please ask. Hello. Yes, so the question is, who is an eyewitness in case of the Samaritan law? The eyewitness is someone who has seen the accident taking place. And who will reward or compensate him? This respective state governments will reward. Fine? Are NRIs eligible for Aadhaar card? If you look at the definition of NRI in Income Tax Act, NRI is an Indian, but who is not ordinarily residing in India for the past 182 days. That's what I said. Any resident in India, whether he's a foreigner or an Indian, if he has ordinarily resided in India 182 days prior to making up of this application, he will get an Aadhaar card. Is it mandatory to enroll? As of now, it is not mandatory. But we see the government is trying and pushing Aadhaar as some sort of a mandatory document for various subsidies. But the Supreme Court position is clear as of now. You cannot enforce Aadhaar. It cannot be made mandatory. It's only voluntary in nature. What is a statutory and a non-statutory body? A body which is created by an act of parliament is a statutory body. A body which is created by a government resolution is a non-statutory body. For example, Niti Aayog was created by a resolution of the government of India. So it's a non-statutory body. But if you look at any other statutory body, for example, National Human Rights Commission, it is created by an act of parliament. So it's a statutory body. Can an Indian refuse to enroll? We have answered this question. Demographic info in the sense, the location, what is my residence? These are the demographic informations. Aadhaar Act was finally passed as a money bill and not a financial bill. The difference between surface-to-surface missile and ballistic missile is on your notes. Please go through them. What is 52 in International Fleet Review? As I said, the 52 countries participated. The navies of 52 countries participated in that International Fleet Review. Voyager 1 was a space probe which was launched by NASA to study outer solar system. And last year, it left the solar system. And one thing also, the note regarding the Indian solar panel dispute, that will be emailed to you. So please go through that. If you do not receive that, send a mail to iaswebinar@byju's.com. Is India going to appeal? Yes, India has said we will appeal against the WTO before the appellate authority. The access to first weeks of webinars will be provided to you. It is already uploaded on the portal. If you do not receive it still, please send a mail, drop a mail at iaswebinar@byju's.com. That will be provided to you. Can you please repeat the topics to be looked from Netaji perspective? Just understand that there are 4 types of classification: top secret, secret, confidential, and restricted. And also try and read everything related to Netaji Subhash Chandra Bose from the modern history point of view. As in, when he became the president of Indian National Congress, then there was a revolt by a group who were loyal to Mahatma Gandhi. Then there was a controversy at Tripuri. Then he left the Indian National Congress and started a forward bloc. So all such information, factual information, please go through them. You might expect a question in modern history. What is the difference between money bill and a financial bill? That is something related to polity. I hope you have read about that. The difference is money bill and financial bill. Both can be tabled only in Lok Sabha and the prior permission of the president is required. But money bill deals with only money matters contained under Article 110. If in any bill there are some money matters and some non-money matters, it comes under financial bill. But money bill, if it is passed by Lok Sabha, sent to Rajya Sabha, if Rajya Sabha does not act on this bill for 14 days, it will be deemed to be passed by both houses of the parliament. But in case of financial bill, Rajya Sabha has an equal role. It can suggest amendments. In case of a deadlock, joint session of Indian Parliament can also be convened. Speaker does not have any role in case of finance bill. She can only certify whether a bill is a money bill or not. Yes, the handouts do have other topics as well, but because the session extended to close more than 2.5 hours, we could not discuss all those topics, but those are factual topics for which no further explanation is required. Just go through these topics once, and I hope you are able to understand. Still, if you're not able to understand, drop me a mail and we will respond. Planning Commission was also a non-statutory body, yes. Yes, Art of Living was able to conduct that program. Bank Boards Bureau is not under RBI, it's an autonomous body.